Motivation. It is the critical issue in the trial of Warren versus Desantis, which gets underway in Tallahassee today. In August, Governor Ron DeSantis unceremoniously removed Hillsborough State Attorney Andrew Warren from office, pointing to pledges Warren signed with other elected prosecutors across the nation not to prosecute cases involving abortion or transgender health care. Warren, a progressive Democrat, who, by the way, never refused to prosecute a case on either issue, accused the Republican governor of political retaliation and violating his right to free speech. Joining me on the morning show, Jonathan Miller, a litigator and chief program officer from the Public Rights Project. Good morning.
Good morning. Thanks so much for having me.
It's our pleasure. Let's get to the issue of motivation. Is there a legal foundation for the governor's move, or is this a clear case of political motivation?
Well, what the documents that we've uncovered through public records requests have shown, and what the trial will show this week, is that Governor DeSantis' removal of Andrew Warren was a political ploy. Governor DeSantis terminated Andrew Warren and ran right onto the Tucker Carlson show. He was aiming to score political points. Now, the governor's power to remove state officials is an extraordinary power. It's enshrined in the state constitution, but it's not a power that should be used casually, and certainly not for political ends. But here, Governor DeSantis removed an elected prosecutor simply because he disagreed with the prosecutor's politics, plain and simple. It's an abuse of power.
So the court's going to have to decide whether Andrew Warren's removal was illegal and a violation of his First Amendment rights. Your thoughts?
Well, let me be very clear on this. This removal was illegal and unconstitutional. As a prosecutor, Andrew Warren has the power and the authority to set priorities, to exercise discretion, and to use his authority in the way that he thinks best reflects the values and needs of the community. That's something prosecutors do every day, every hour that they're on the job. But Governor DeSantis disagreed with Andrew, considered him a political opponent, and so he removed him. He removed him because of his disagreement on his views on abortion. He removed him because of his disagreement on LGBTQ equality. That violates the First Amendment. And this power of removal is meant for things like when an official doesn't show up for work or engages in illegal activity, not when there's a political disagreement about prioritization.
I want to get more to the issue of discretion in a minute, but first, I want to talk about Warren's attorneys being willing to avoid letting Governor DeSantis testify in a deposition for now, as long as they can put him on the witness stand later. Even though the judge as much as said the governor's thoughts and motivations are crucial to this case, a strategic move for the Warren team?
Well, it certainly might have made for an interesting spectacle to have Governor DeSantis on the witness stand, but the governor's testimony is not needed for the case. There are plenty of witnesses and documents that can speak to the governor's true motivation. Let me give you an example. In some of the documents we viewed, the governor's office put together an analysis of the financial cost of the earned media received from the decision to illegally remove Andrew Warren. The governor's office estimated in those documents $2.4 million in earned media that they received from the news around the removal. They were so concerned about the press interest, they calculated the value. Those are the types of documents and information that will come out at trial.
So is this case much bigger than just Andrew Warren? Isn't the bigger question the ability of prosecutors to employ prosecutorial discretion? Isn't discretion something they routinely employ?
Certainly, this case is much bigger than just about Andrew Warren. And that's true, I think, for Florida and nationally. In Florida, this is part of a troubling trend from a governor who can't handle really any dissent and lashes out against anyone who disagrees. And nationwide, you're absolutely correct. There are threats around the power of prosecutors to exercise their discretion, to implement reforms that they believe improve public safety. And there are actually now lots of studies around the country that show things like removing cash bail, refusing to prosecute certain types of offenses actually improve community safety by keeping families together, by keeping people earning money, and by keeping people out of the criminal justice system. So we're seeing nationwide pushback, particularly by conservative state legislatures, to remove this discretionary authority from prosecutors and to basically eliminate the ability of communities to elect leaders that reflect their values and to implement the changes that they want to see within their cities and towns.
Jonathan Miller, we'll see where the court rules. If it rules in Andrew Warren's favor, he hopes to be back in his office shortly after that court ruling. Appreciate your time and your opinion.
Thank you.